Though it's unlikely that Donald Trump, the former president of America, will face any more criminal trials before Election Day, he will still get another day to appear in court on September 26th. That's when the New York Court of Appeals will hear his case to overturn a $454 million judgment that was rendered against him for deceiving lenders. The arguments were scheduled for that day by the Manhattan-based appeals court, offering Trump the opportunity to refute trial Judge Arthur Engoron's finding that he falsely inflated the worth of his assets to obtain better conditions for a loan and insurance. Arthur F. Engoron, an American judge serving on the Manhattan Supreme Court, held Trump and a few of his businesses accountable for $454 million with growing interest. Additionally, Trump's two eldest sons, Eric and Don Jr., and former Trump Organization CEO Alan Weisselberg, were subject to a separate obligation of roughly $10 million imposed by Engoron. The Republican presidential nominee's attorneys contend in his appeal that James missed the deadline to file the lawsuit against him. To prevent James from seizing Trump's assets while his appeal is pending, the appeals court granted Trump and his co-defendants permission to post a bond of just $175 million instead of the entire judgment. This is the second time the court has aided Trump in this matter. The bond prevented New York Attorney General Letitia James's office from taking action to take over properties or bank accounts. A recent attempt by Trump's attorneys to remove Engoron from the case was unsuccessful. According to Engoron, the other attorney accosted him, and he didn't base any of his decisions on that interaction. Because Engoron placed continuing conditions on the defendants, such as having an independent monitor continue to watch the Trump Organization, he has jurisdiction over the case, even while it is on appeal. The prosecutors wrote that, as the Supreme Court rightly explained, the interest rate savings and the sale profits represent a separate category of ill-gotten profits, causally connected to the defendant's use of the false and misleading statements, and they were not mutually exclusive theories of recovery.